Welcome, welcome. Welcome to Constitution Day on this beautiful fall day. Thank you all for being here with us, with the federal court family of the Eastern District of California. It is so wonderful to see so many friends, judges, lawyers, members of the community, students in particular. For the last time, I'm welcoming you as Chief Judge of the Eastern District of California. In just a few moments, I'm going to yield that gavel very happily. But first, to start this celebration in the right way, please join me in welcoming the Junior ROTC from McClatchy High School to present the colors, and the McClatchy High School Choir to sing the national anthem.
Color guard, left, face, carry, close. Freeze and colors.
Oh, say can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave.
Colors. Dismount. Colors. Left, face. Single file. Roger.
Thank you to McClatchy students. Please join me in thanking them once again. Today is the Constitution's birthday. That's why we do this today. It also happens to be my birthday, and that only matters for one reason. That matters for one reason today. When a federal judge satisfies the rule of 80, that means that judge can take what we call senior status. I have just turned 67, according to my parents, 12:15 Central Standard Time. I have served 13 years, according to our HR director. So I have satisfied the rule of 80, 67 plus 13. I would not have to take senior status. In our court, I do that, we do that, because that's how we get additional judicial resources. And I'm hoping my successor will join our bench officially later this week, but I'm clearing the way for that. Also, a senior judge cannot be chief judge. And so, again, as I said, I'm happily yielding the chief judge gavel. Just briefly, in the lower courts, the federal appellate and trial courts, chief judges step up based on seniority when we are willing and able to serve as the chief in an administrative role. We do that as part of the judiciary's maintaining our independence and also hopefully proving to all of you, to members of Congress, to the other branches, that we can manage ourselves. It's important that we manage ourselves to maintain our independence. Someone soon will read Article 3. We serve subject to life with good behavior. So that self-management is a part of ensuring that we behave well, and if we don't, we are held accountable. It has been my distinct honor and privilege to serve as Chief Judge of the amazing Eastern District of California, a hardworking bench, a very productive bench, a diligent, dedicated bench of public servants supported by a deep bench of public servants working for Keith Holland in our clerk's office, Minnie McQuibby in our probation office, Beth Wetland now in our pretrial services office. And to see all of you, again, members of the court family, members of the community that show up for jury service, students who are learning about us and will help carry on what it means to have a strong third branch. So with that, I am going to yield the Chief Judge gavel to my successor, and I want you all to see what a big gavel it is. This is my career clerk, Brian Pulsifer. You see that he can handle it quite easily. He's young and strong. It's going to take me a little more, so I'm going to give up the mic, and then the mic will be Judge Nenley's.
I don't know about this. Oh! I get banged in the head.
I give you Chief Judge Troy Nunley.
We all don't have gavels this big on our bench. Our gavels are really small. You know, today really is fortuitous that we have Constitution Day, and we also have the passing of the Chief Judge gavel today. It's just fortuitous that Judge Mueller chose this day. This is a labor of love. Constitution Day is a labor of love started by Judge Mueller. And it's a very important time for us to remember the importance of the Constitution to the United States. And she realized that several years ago. She instituted Constitution Day, and it's going to remain a mainstay of our court, at least as long as I'm Chief Judge, which could last a week, a day, a few years. Who knows? But it's really not about, today is really not about that. The most important thing really is Constitution Day. I want to thank members of the community. I see we got attorneys, we have certainly judges, we have members of the military, and most important, we have parents, but most important, we have kids. And I want the kids to realize really how important the Constitution is to this country in the reading. And really, in the past when we've done this, it really hits home to me at least, and I think I've talked to several other adults, how important the Constitution is, especially when you hear it come from the mouths of our youth. And so with that being said, this really is not about me, so I'm going to end my words, and I'm just going to say, as my first act as Chief Judge, I'm going to introduce some of our judicial clerks, both from the United States District Court for the Eastern District of California, as well as from the Ninth Circuit Court of Appeals, who will do a choral reading of the preamble.
Greg, get the second mic.
Nosotros la gente.
我们人民
Wir das Volk.
Nous le peuple, 우리는 국민들.
We the people of the United States.
in order to form a more perfect union,
Establish justice.
ensure domestic tranquility,
Provide for the common defense.
Promote the general welfare.
and
And secure the blessings of liberty.
to ourselves
and our posterity,
do ordain
and establish
this Constitution for the United States of America.
Article 1, Section 1. Article 1, Section 1. Tous les pouvoirs législatifs accordés par le présent acte seront attribués à un Congrès des États-Unis qui se composera d'un Sénat et d'une Chambre des représentants. Section 2. Section 2. La Chambre des représentants se composera de membres choisis tous les 2 ans par le peuple des différents États et, dans chaque État, les électeurs devront posséder les qualifications requises pour être électeurs à l'Assemblée la plus nombreuse de la législature de l'État. Nul ne pourra être représentant à moins d'être âgé de 25 ans, d'être depuis 7 ans citoyen des États-Unis et d'habiter au moment de son élection l'État dans lequel il sera élu.
Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all other persons. This infamous 3/5 clause in the Constitution was eliminated in 1868 by the 14th Amendment.
La enumeración real se efectuará en el curso de los 3 años siguientes a la primera reunión del Congreso de los Estados Unidos y después en cada periodo subsiguiente de 10 años, en la forma en que aquel lo dispusiere por ley. No habrá más de un representante por cada 30,000 habitantes, pero cada estado tendrá por lo menos un representante. En tanto se realizar la enumeración, el estado de New Hampshire tendrá derecho a elegir 3 representantes. Massachusetts, 8. Rhode Island y los Providence Plantations, 1. Connecticut, 5. New York, 6. New Jersey, 4. Pennsylvania, 8. Delaware, 1. Maryland, 6. Virginia, 10. North Carolina, 5. South Carolina, 5. Y Georgia, 3. Cuando ocurran vacantes en la representación de cualquier estado, la autoridad ejecutiva de esta emitirá mandamientos de elección para cubrir tales vacantes. La Cámara de Representantes elegirá a su presidente y a otros funcionarios, y solo ella tendrá la facultad de iniciar procedimientos de juicio político.
Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the 2nd class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, The executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. The 17th Amendment, adopted in 1913, changed this section of the Constitution to permit the direct election of U.S. senators.
No person shall be a senator who shall not have attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate,
but shall have no vote unless they be equally divided. The Senate shall choose their other officers and also a president pro tempore. In the absence of the Vice President, or when he shall exercise the office of President of the United States.
The Senate shall have sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present.
Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law.
Article 1, Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. The 20th Amendment, adopted in 1933, changed the date on which Congress convenes, January 3rd.
Each house shall be the judge of the elections, returns the qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may be adjourned from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide.
Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member.
Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgments require secrecy. And the yeas and the nays of members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting.
Article 1, Section 6. The senators and representatives shall receive a compensation for their services to be ascertained by the law and paid out for the Treasury of the United States. They shall, in all cases except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house. They shall not be questioned in any other place.
No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office.
Article 1, Section 7.
All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to the House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of the House, it shall become a law.
But in all such cases, the votes of both houses shall be determined by the yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress, by their adjournment, prevented its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be passed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill.
Article 1, Section 8. Artigo 1, seção 8. Será da competência do Congresso lançar e arrecadar taxas, direitos, impostos e tributos, pagar dívidas e prover a defesa comum e o bem-estar geral dos Estados Unidos, mas todos os direitos, impostos e tributos serão uniformes em todos os Estados Unidos, levantar empréstimos sobre o crédito dos Estados Unidos, regular o comércio com as nações estrangeiras entre os diversos estados e com as tribos indígenas, estabelecer uma norma uniforme de naturalização e leis uniformes de valência para todo o país.
To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited times to authors and investors the exclusive right to their respective writings and discoveries, to constitute tribunals inferior to the Supreme Court.
To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water.
To raise and support armies, but no appropriation of money used to that use shall be for a longer term than 2 years. To provide and maintain a navy, to make rules for the government and regulation of the land and naval forces.
To provide for calling forth the militia to execute the laws of the Union and suppress insurrections and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress.
to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of forts, magazines, arsenals, stockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested in this by the Constitution and the government of the United States or in any department or officer thereof.
Article 1, Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. The use of the phrase "such persons" refers to enslaved people forcibly brought to America from Africa to labor in the building of the United States. When the Constitution was written in 1787, importation of slaves was permitted into the United States for 20 more years. Beginning January 1st, 1808, the importation of slaves in the transatlantic slave trade was outlawed by Congress, although slavery was not outlawed for 57 more years.
The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it.
No bill of attainder or ex post facto law shall be passed.
No capitation or other direct tax shall be laid, unless in proportion to the census or enumeration herein before directed to be taken.
The 16th Amendment, adopted in 1913, changed this clause of the Constitution to permit the federal income tax. No tax or duty shall be laid on articles exported from any state.
No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties to another.
No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time.
No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present emolument, office, or title of any kind whatsoever, from any king, prince, or foreign state.
Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility.
No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of Treasury of the United States. And all such laws shall be subject to the revision and control of the Congress.
No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. Article 2, Section 1. The executive power shall be vested in the President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows.
Each state shall appoint in such manner as the legislator thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed and elected.
The electors shall meet their representative states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all persons voted for and of the number of votes each, which list they shall sign and certify and transmit sealed to the seat of government of the United States, directed to the President of the Senate.
The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted.
Thank you.
The person having the greatest number of votes shall be the president. If such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have a majority, then from the 5 highest on the list of the said House shall in like manner choose the president.
But in choosing the president, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. The 12th Amendment, adopted in 1804, changed the way the president and vice president are chosen.
کنگره باید زمان انتخاب کنندگان، روز رای دادن آنها و روزی که در سراسر کشور یکسان باشد را تعیین کند. هیچ کس به جز یک شهروند متولد آمریکا یا یک شهروند آمریکا در زمان انتخاب این قانون اساسی واجد شرایط دفتر ریاست جمهوری نیست. همچنین هیچ کس واجد شرایط دفتر ریاست جمهوری نیست که اگر کمتر از 35 سال سن داشته باشد و یا کمتر از 14 سال در آمریکا ساکن باشد.
In case of the removal of the president from office, or his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or a president shall be elected. The 25th Amendment, adopted in 1967, altered the method of presidential succession described in this clause.
The president shall, at stated times, receive for his services and compensation, which shall neither be increased nor diminished during the period for which he shall be elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States.
Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion, in writing, of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offices against the United States, except in cases of impeachment.
He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law.
But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session.
Artículo 2, sección 3. El presidente informará al Congreso sobre el estado de la Unión y le recomendará las medidas que él estime convenientes y necesarias. En ocasiones extraordinarias podrá convocar a ambas cámaras o a cualquiera de ellas, y en caso de desacuerdo entre las cámaras con respecto a la fecha del receso, el presidente podrá determinarlo cuando juzgue necesario. Él recibirá a los embajadores y otros ministros públicos. También velará por el fiel cumplimiento de las leyes y autorizará los nombramientos de todos los funcionarios de los Estados Unidos.
Article 2, Section 4. 제2조 4절. 대통령, 부통령, 그리고 미국의 모든 문건에 반역죄, 수뢰죄 또는 그 밖의 중대한 범죄 및 경범죄로 탄핵받고 유죄 판결을 받음으로써 면직된다.
Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office.
Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party,
to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects.
In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed.
Article 3, Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except in the life of the person attainted.
Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof.
Article 4, Section 2, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime.
No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. The 13th Amendment, abolishing slavery in 1865, eliminated the fugitive slave clause from Article 4 of the Constitution.
Article 4, Section 3. New states may be admitted by Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states, or parts of states, without the consent of legislatures of the states concerned, as well as of Congress.
The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state.
Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence.
The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures, 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states.
Or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate.
Article 6, all debts contracted and engagements entered into before the adoption of this Constitution shall be valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding.
The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States.
The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, the 12th in witness whereof we have unto subscribed our names. George Washington, President and Deputy from Virginia.
New Hampshire, John Langdon, Nicholas Gilman. Massachusetts, Nathaniel Gorham, Rufus King. Connecticut, William Samuel Johnson, Roger Sherman. New York, Alexander Hamilton. New Jersey, William Livingston, David Brearley, William Patterson, Jonathan David.
Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Jared Ingersoll, James Wilson, Governor Morris. Delaware, George Reed, Gunning Bedford Jr., John Dickinson, Richard Bassett, Jacob Broom.
Maryland, James McHenry, Daniel of St. Thomas Jennifer, Daniel Carroll. Virginia, John Blair, James Madison Jr. North Carolina, William Blount, Richard Dobbs Spate, Hugh Williamson.
South Carolina, John Rutledge, Charles Cotsworth Pinckney, Charles Pinckney, Pierce Butler. Georgia, William Few, Abraham Baldwin, Attest William Jackson, Secretary.
The preamble to the Bill of Rights. Congress of the United States begun and held at the City of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states, having at the time of their adopting of the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution.
Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of the said legislatures, to be valid to all intents and purposes as part of said Constitution.
Articles in addition to an amendment of the Constitution of the United States of America, proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. These amendments were ratified December 15, 1791, and form what is known as the Bill of Rights.
The First Amendment. 第1条修正案，国会不得指定关于下列事项的法律，确立国教或禁止宗教活动自由，限制言论自由或出版自由，或剥夺人民和平集会和向政府请愿申冤的权利。
Amendment 2, a well-regulated militia being necessary to the security of a free state The right of the people to keep and bear arms shall not be infringed.
Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized.
To the Fifth Amendment, in Arabic. التنقية الخامس لا يجاوز اعتقال أي شخص لاستخدامه بشأن جنائية أو جريمة شأنها أخرى إلا تبع لصدور قرار اتهامي أو مطابقة اتهامي تنحية الحلفين كبرى باستثناء القضية الحاصلة في قوة البرية وبحرية وفي الميليشيا. عندما تكون هذه القوات في الخدمة الفعلية وقت الحرب أو الخطر العام. ولا يجوز يتهم أي شخص بنفس الجرم متبين فتتعرض حياة وعدى بدون إلا خطر، كما لا يجوز إكراه أي شخص في أي دعوى جنائية على أن يكون شاهد ضد نفسه، ولا أن يحرم من الحياة والحرية ومعتقلات دون إتباع الإجراءات القانونية الأصولية، كما لا يجوز نزع أي ملكية خاصة باستخدامها في سبيل منافع العام بدون تعويض عدل.
Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial, speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed. Each district shall have been previously ascertained by law and to be informed of the nature of the cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Amendment 7, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Amendment 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Amendment 9, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
Amendment 11. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state.
Amendment 12. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit, sealed to the seat of the government of the United States, directed to the President of the Senate.
The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president. If such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president.
But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice.
If the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the Vice President shall act as President, as in the case of death or other constitutional disability of the President. This clause in Amendment 12 was superseded by Section 3 of the 20th Amendment in 1933.
The person having the greatest number of votes as vice president shall be the vice president if such number be a majority of the whole number of electors appointed. And if no person having a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States.
Amendment 13, Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have the power to enforce this article by appropriate legislation.
Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
Note, Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. Amendment 14, Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed.
But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. The 19th Amendment in 1920 nullified the restriction of voting only to male citizens. The 26th Amendment in 1971 lowered the voting age to 18.
Amendment 14, Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in an insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability.
Amendment 14, Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article.
Amendment 15, Section 1. Ni los Estados Unidos ni ningún otro Estado podrán desconocer ni menoscabar el derecho de sufragio de los ciudadanos de los Estados Unidos por motivo de raza, color o de su condición anterior de esclavos. Section 2. El Congreso estará facultado para hacer cumplir este artículo mediante leyes apropiadas.
Amendment 16. El Congreso tendrá facultades para establecer y recaudar impuestos sobre los ingresos, sea cual fuere la fuente de que provengan, sin prorratearlos entre los diferentes estados y sin atender a ningún censo o recuento.
The Senate and of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors of each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature.
When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue the writs of election to fill such vacancies.
Provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution.
Amendment 18, Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited.
Amendment 18, Section 2. The Congress and the several states shall have concurrent powers to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress.
Amendment 19, in Spanish. El derecho de los ciudadanos de los Estados Unidos al sufragio no podrá ser denegado o coartado a causa del sexo, ni por los Estados Unidos ni por ningún Estado. El Congreso tendrá facultades para hacer cumplir las disposiciones de este artículo
por medio de la legislación apropiada.
Amendment 20, passed by Congress March 2nd, 1932, ratified January 23rd, 1933. Section 1. The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January, of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin.
Amendment 20, Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd of January, unless they shall by law appoint a different day. Note Article 1, Section 4 of the Constitution was modified by Section 2 of the 20th Amendment.
Good job.
Amendment 20, Section 3. Note, a portion of the 12th Amendment was superseded by Section 3 of Amendment 20. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of their term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President has been qualified.
And the Congress may, by law, provide for the case wherein neither a President-elect nor a Vice President shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified.
Amendment 20, Section 4. The Congress may by law provide for the case of the death of any of the persons for whom the House of Representatives may choose a president whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a vice president whenever the right of choice shall have devolved upon them.
Amendment 20, Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission.
Amendment 21, passed by Congress February 20th, 1933, ratified December 5th, 1933. Section 1, the 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2, the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited.
Amendment 21, Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress.
Amendment 22, passed by Congress March 21st, 1947, ratified February 27th, 1951. Section 1. No person shall be elected to the office of President more than twice. And no person who has held the office of President or acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of President more than once.
But this article shall not apply to any person holding the office of President when this article was proposed by Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term in which this article becomes operative, from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress.
Amendment 23, passed by Congress June 16, 1960, ratified March 29, 1961. Section 1. The district constituting the seat of government of the United States shall appoint in such a manner as Congress may direct the number of electors of president and vice president equal to the number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state.
They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of the president and the vice president to be the electors appointed by the state, and they shall meet in the district to perform such duties as provided by the 12th article of amendment. Amendment 23, Section 2. The Congress shall have the power to enforce this article by appropriate legislation.
Amendment 24, passed by Congress August 27, 1962, ratified January 23, 1964. Section 1, the right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. Section 2, the Congress shall have power to enforce this article by appropriate legislation.
Amendment 25, passed by Congress July 6, 1965, ratified February 10, 1967. Notes: Article 2, Section 1 of the Constitution was modified by the 25th Amendment. Section 1. In case of the removal of president from office or of his death or resignation, the vice president shall become president. Section 2. Whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirmation by a majority vote of both houses of Congress.
Amendment 25, Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President.
Amendment 25, Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President.
Thereafter, when the President transmits to the President pro tempore of the Senate and Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session.
if the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office.
Amendment 26, passed by Congress, March 23rd, 1971, ratified July 1, 1971. Note, Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment.
Amendment 26, Section 1. The rights of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age.
Section 2. The Congress shall have power to enforce this article by appropriate legislation.
Thank you. I can read this part. You can read that part. Do you want to do that? All right. Amendment 27, originally proposed September 25th, 1789, ratified May 7th, 1992.
No law bearing the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened.
Woohoo!
This concludes our reading of the Constitution of the United States of America. On behalf of the Chief U.S. District Judge of the Eastern District of California, Troy L. Nunley, the immediate past Chief District Judge, Kimberly J. Mueller, the Sacramento chapter of the Federal Bar Association, Operation Protect and Defend, the Ninth Circuit's Justice Anthony M. Kennedy Learning Center, and the Ninth Circuit Library's branch librarians, thank you very much for joining us today. Have a great afternoon.